Bertrand Kowalski slid the deed transfer across the hospital cafeteria table like he was passing me a napkin. Mom's already signed it. You just need to initial here, and the assisted living facility gets its deposit by Friday. I looked at the paper, then at my brother's face, calm as a man discussing the weather. I didn't argue. I signed nothing. I drove home and pulled the security footage from the nursing station camera I'd quietly had installed 8 months earlier, the one Bertrand didn't know existed. My name is Corinne Ashby, I'm 42, and I'm a hospital administrator at Fairmont Regional Medical Center in upstate New York. My mother, Delphine Ashby, built a modest but stable rental property portfolio over 30 years. 11 small apartment buildings she managed herself out of a converted garage office. The kind of quiet wealth nobody in town knew existed until it mattered. 2 years ago, a stroke took her speech and most of her mobility, and she moved into Brookhaven Assisted Living. I was named her healthcare proxy and financial power of attorney the same week, in front of her own attorney, while she could still nod her approval clearly. My brother Bertrand had never once visited the property office in his life, until 3 months after Mom moved into Brookhaven. Then, suddenly, he was calling the property manager, a woman named Charlene who'd worked for my mother for a decade, asking pointed questions about rent rolls and which buildings carried the least debt. When I asked him about it over dinner, he laughed and said he was just getting familiar with the family business in case Mom needed help. When I pressed a second time, he turned cold and told me I was being controlling, that I'd always treated Mom's affairs like they were mine alone to manage. Why did Charlene mention that Bertrand had asked her, twice, whether Mom still recognized her own signature? I let it sit. 2 weeks later, Charlene called me directly, her voice tight, to say a man from a title company had phoned asking to verify ownership records on the 2 apartment buildings with the highest resale value. She hadn't authorized any inquiry. I checked the county recorder's site that same night and found a quitclaim deed filed 11 days earlier, transferring both buildings from my mother's trust into a newly formed LLC. The registered agent was Bertrand's wife's cousin, a paralegal named Denise who worked 2 towns over. I didn't confront him yet. I drove to Brookhaven the next morning and sat with my mother for an hour, holding up index cards with yes and no boxes the speech therapist had taught her to point to. I asked her, slowly, if she remembered signing any paperwork about the buildings. She stared at the card for a long moment, then pointed, with visible effort, to no. Her hand was shaking, but the answer was unmistakable. I photographed the card and the date on my phone and said nothing to the staff beyond thanking them for their patience. That evening Bertrand called, breezy, asking if I'd looked over the transfer paperwork yet. I told him I hadn't decided. He said Mom wanted it done quickly, that she'd told him herself she was tired of managing the properties and wanted them consolidated under family control, before anything happened to her. I let him keep talking. I didn't mention the index card. I didn't mention Denise. I said I needed a few more days to think. Instead, I called an elder law attorney named Priya Vasquez, someone with no connection to our family, and laid out everything. The LLC filing, the timing, Charlene's account of the title inquiry, the index card. She told me the quitclaim deed required either my mother's notarized signature or my authorization as her proxy, and neither had been given. She pulled the recorded deed herself. The notary block listed a name, Harold Fenwick, whose license, when Priya checked the state registry, had expired 18 months earlier. The signature above it did not match any signature on file from my mother's original trust documents. It matched, instead, a looping, over-careful hand that Priya, after comparing samples, said looked practiced, like someone had traced it slowly from an old check. I still said nothing to Bertrand. For 6 weeks I let him believe the paperwork was moving forward. He grew confident, mentioning at a family barbecue that he'd already gotten a preliminary offer on one of the buildings from a developer. Casually, in front of our cousins, like it was already his to sell. I smiled and passed the potato salad. I let him keep talking, because every word he said in front of witnesses was one more thing Priya could later put in a sworn statement. Then came the mistake that mattered. Bertrand, impatient with how slowly the sale was moving, called Brookhaven directly and asked a nurse to have my mother initial a supplemental document for her son's business. The nurse, uneasy, refused and documented the request in Mom's chart per facility policy, a note that read, verbatim, family member requested signature outside of scheduled proxy visits, declined per protocol, notified administrator. That note, dated and time-stamped, became the second nail. I brought everything to Priya, the recorded deed, the expired notary license, the index card response, the facility's declined request note, and finally the security footage from the nursing station camera, which showed no visit from Bertrand or Denise, on the date the deed claimed my mother had signed it in person at Brookhaven. The footage showed, instead, an empty hallway. Priya filed a petition with the county court to void the transfer for lack of capacity and fraudulent execution, and separately referred the matter to the district attorney's Elder Financial Abuse Unit. I did not call Bertrand to warn him. I let the sheriff's civil process server do that. He called me 11 times the day he was served, then showed up at my house that evening, still in his work clothes, pounding on my door hard enough that my neighbor's motion light snapped on. When I opened it, he was already talking, insisting I'd blindsided him, that this was supposed to stay a family matter, that I'd humiliated him in front of Denise's whole family by looping in lawyers. I told him the only humiliation here belonged to whoever forged our mother's signature using an expired notary and a paralegal cousin, and that the facility's own chart notes would say the rest in court. Something in his face changed then, not guilt exactly, but the specific fear of a man realizing the paper trail was longer than he'd planned for. He tried softening after that, said Mom really had talked about wanting to simplify things before the stroke, that he'd only moved fast because he was worried I'd let the properties sit idle. I told him there was no version of that explanation that accounted for an expired notary license or a nursing chart entry documenting a refused signature request. He stopped talking. I closed the door. The court hearing 3 months later was brief. Priya presented the deed, the notary registry printout, the facility records, and my mother's own witnessed index card response, admitted through her speech therapist's testimony. Bertrand's attorney argued confusion, not intent. The judge voided the transfer, restored the properties to the trust, and referred the notary question to the state licensing board. The district attorney's office, reviewing the same file, offered Bertrand a plea to a reduced charge of attempted fraud against a vulnerable adult, with restitution for legal costs and 5 years probation, rather than pursue a felony trial that would have dragged our mother into a courtroom she could no longer navigate. He took it. My mother's care team helped me explain the outcome to her in small, patient pieces over several visits. She cried the first time she understood what her signature had allegedly authorized. By the third visit, she simply squeezed my hand and pointed, slowly, to a card that said thank you. Charlene still manages the properties, now under a court-monitored trustee arrangement that requires 2 independent signatures for any transfer over a set threshold, a safeguard Priya insisted on precisely because paper, unlike memory, doesn't fade with a stroke. Bertrand and I haven't spoken since the plea hearing. I've made peace with that. Some repairs cost more than a family is willing to pay, and I'd rather carry the quiet than carry the guilt of having stayed silent while someone traced my mother's signature onto a stranger's ledger. I think sometimes about that empty hallway on the security footage, proof sitting there the whole time, waiting for someone patient enough to go looking. If you'd found that footage first, would you have shown it to him that same night? Or would you have waited, the way I did, until the court could no longer look away from it?